Hello, good morning friends. Welcome to the CEC Edit live lecture. Dear friends, as you know that we are carrying a very new series on intellectual property, and you know that since our previous two lectures we are talking lots on intellectual property. I could say that these were the introductory lectures and the topic of our lectures were introduction to intellectual property and its relevance in the today's world. Dear friends, we are going to continue this very topic, that is introduction to intellectual property and its relevance in today's world. And I would like to tell you all, this is the third lecture I would say on the introductory portion, and we would be carrying more lectures on intellectual property in our forthcoming lectures, forthcoming sessions. But for today, as I already said, this is the third and the last on the introductory portion. So dear friends, for this we have again with us in our studios Mr. Ashwani Sehwal. Ashwani Sehwal is Assistant Professor in Intellectual Property and Data Security Laws in Faculty of Law, University of Delhi. As well as I would like to tell you all that Mr. Sehwal has attended, participated and organized various seminars, conferences both at the national and international level. Here he frequently visits various countries where he participates in the exchange programs, that is knowledge exchange programs. I hope that with the help of his knowledge, with the help of his experience, we are going to learn more through him. So without wasting any time, I would like to welcome our guest, Mr. Ashwani Sehwal. Mr. Sehwal, welcome to the Edit lecture.
Thank you very much.
I hope that this session is going to be one of the most productive sessions, because the way you have delivered your previous sessions, they have given most to the students, and I pray and I wish the same for this lecture too.
Thank you very much. Thank you, Gitika. Welcome viewers. First of all, I would like to wish to all the viewers World Environment Day. I'll begin with this wish to all of you. We will have to save the environment for the future generations. Keep this motto in your mind and go ahead with the good things for the environment, for you, for your family, for the people at large. Well, as far as the last lecture on the introduction to intellectual property, first of all, I would like to take the viewers a quick recapitulation of certain important things that we covered yesterday. If you remember, viewers, yesterday we dealt with three important issues. The one, historical evolution of the intellectual property. We exhaustively saw as to how intellectual property has evolved over the period of time, not only in India, rather in other countries also, I mean across the world. And then we saw certain important legislations existing in India, their salient features. And the third important part that we were covering, that we did not complete yesterday, was the international instruments relating to intellectual property. We dealt two important, very indispensable international instruments yesterday in our discourse. The Paris Convention relating to industrial property. As I mentioned, industrial property basically used to mean trademarks and patents. It did not cover rest of the intellectual properties. I mean, copyright was not covered by the Paris Convention. Then we had the Berne Convention. The salient features of the Berne Convention was discussed by me in the yesterday's discourse. The salient features I would like to recapitulate for the viewers in a 2 minutes time or a 1 minute time. As far as the Berne Convention for the literary and artistic work is concerned, in that convention we found that there was a recognition given even to the performers' right, recognition given to the moral rights of the people, to the authors, or moral rights of the any copyrightable subject matter. Apart from that, in the Berne Convention, we saw that there was no requirement of formality for the registration of the copyright, but in many other conventions, it was the requirement as one of the most requisite, the prerequisite for obtaining the copyright, to register it first of all. Let's proceed with today's discourse, friends. The new, or say the other conventions, the international treaties, the international instruments will take up today. And after that, in today's discourse, I would like to put across certain good examples to the viewers to understand the different kinds of intellectual property. We'll see certain images wherein I'll tell you that these are the things which are protected by the intellectual property, respective intellectual properties, I mean, say patents, copyright, trademarks and other intellectual property protections are given to those particular things. Let's start with the first international instrument that we'll have to cover today. It's the Patent Cooperation Treaty. Friends, as the name suggests, it is basically for the simplification of international patent filing. As I mentioned in the yesterday's class, in the yesterday's discourse, that it's not possible, or it was humanly impossible for the applicant owning a good invention, having an inventive step or everything, to get it patented in several countries in one go, because there were certain hiccups, certain inhibitions as to the procedure, or even in the substantive laws of different nations, there were certain differences available. So for making it easier and facilitating the applicant to get a property protection in the form of the patents in all the nations in one go, this Patent Cooperation Treaty of 1970 is a landmark treaty wherein the procedure for obtaining the patent in different countries by filing internationally was for the first time recognized. This agreement of international cooperation is for the field of the patents, as the name suggests, that Patent Cooperation Treaty, and it is a special agreement under the Paris Convention, open only to states which are already part of that convention. Friends, that's all we need to see about the Patent Cooperation Treaty. Let's have a look on the next treaty that is very important to my understanding. It's the Budapest Treaty of 1980. The salient features of this treaty I would certainly tell to all of you, but before that I would like to give you a little bit background as to why it was required to have a Budapest Treaty. As the name of the treaty suggests, that it's a treaty for the recognition of international deposition of the microorganisms or depositories of microorganisms. See friends, in the case of the patents, the inventions of the patent subject matter can involve microorganism as one of the part, or the whole invention may be based on the microorganism. So in that case, whenever the applicant files the patent application, he or she is required to make the disclosure with the specification, and in that specification, that particular applicant is required and supposed to furnish all the best known methods to him and to furnish rest of the details relating to his or her invention. If this particular application is based on an invention which involves microorganisms in it, he has to disclose that microorganism, or say, as per this treaty, he has to deposit that particular microorganism into the International Depository Authority. Once he deposits the microorganism into the International Depository Authority, that microorganism remains forever with that international depository, and it becomes what? A part of culture collection for them. Whenever it will be required by any country to check the anticipation, to check other requirements, the procedural requirements for obtaining the patent, they can always see whether there exists any such kind of a microorganism in any of the depositories. If it exists, undoubtedly that's in the and that would not be given a patent. If it does not exist in any of the depositories, certainly the applicant will fetch the patent protection on the claim made by him on that particular invention involving a microorganism. So this Budapest Treaty is based on the principle of disclosure, and friends, the principle of disclosure is the base of the patent regime. If you remember, in the very first lecture, I discussed about the role of the intellectual property, wherein I emphasized on the point that intellectual property does two functions or plays two important roles. One, it gives a right to the private person. Another, it gives a right to the public at large also. And it does that by way of striking a balance between these two separate contrasting rights, one of the individual, one of the public at large. So see, whenever any individual, the private person, the individual, goes to the patent office with his claim for an patent protection, he has to certainly, necessarily disclose the best known method of the working of the claim to the patent office. With that disclosure, as I mentioned, the principle of disclosure is the sine qua non of the patent, is the very important part of the patent regime. He has to disclose it. When he discloses it, that disclosure is, given to the public at large to understand the working of the invention, the best known method of the working of the invention known to the inventor, the applicant, right? That is how it gets disclosed, and with that disclosure, the public at large will get benefited in the manner that the public or other researchers involved in the same research will never gonna engage or waste their energy and money into the same kind of a research, as they have been informed through that disclosure that it is into the public domain now. So Budapest Treaty is a very important treaty from the two perspectives. One, it is based on the principle of disclosure. Another, that it recognizes the establishment of international depositories of microorganisms in the case of patenting of microorganisms. And friends, by the purview of the Patents Act 1970, under section 3 of the Patents Acts, microorganisms are allowed to be given patent protection. It's explicitly written over there that patent can be given on the inventions involving microorganisms. Fine, we'll proceed ahead with the next important treaty or international instrument relating to intellectual property, that's Madrid Agreement. Friends, Madrid Agreement came into being in 1891. We have a Madrid Protocol of 1989 also. So both these things, Madrid Agreement of 1891 and the Madrid Protocol of 1989, work together for a common goal, and the common goal of this agreement and the protocol is to govern the system of international registration of marks. International registration of marks. The same difficulty was faced by the people or applicant of the trademarks. The way applicants for the patents used to face the difficulty in getting a patent in many countries, or say international patent, the same difficulty was faced by the trademark owners to have a trademark registered in many countries. So to overcome that difficulty, to basically preclude that particular difficulty or obstruction, Madrid Agreement along with the Madrid Protocol of 1989 served the common goal of international filing of the trademarks. I means the Madrid Agreement as well as the Madrid Protocol has made the international filing very cost effective, friends, and it has made it very easy for the applicant to go to one office and to pay one fee at one point of a time, right? So these are the few salient features of the Madrid Agreement or say Madrid Protocol which are important for the trademarks. And as I mentioned in the very second lecture, I mean yesterday's lecture, that we first of all deal with the WIPO administered treaties. Friend, mind it, these all are the WIPO administered treaties which I am discussing right now. This Madrid Agreement, Madrid Protocol is also a WIPO administered treaty. The earlier treaty, the Budapest Treaty, is also a WIPO administered treaty. And before that we dealt Paris Convention, the Berne Convention, these are also WIPO administered treaties. Friend, I will tell you what is the difference between the WIPO administered treaties and the treaties administered by World Trade Organization, by UNESCO, by other international organizations. There lies a difference between these two sets or these two different regimes altogether, but they are working in tandem for the common good and the common goal, and that is to facilitate the owners of the property to own intellectual property in different nations and in their nations without any obstructions, as well as the common goal of these various treaties, be it a WIPO administered treaty or a treaty administered by other any international organization. The common goal of both these treaties is to have an effective enforcement mechanism for the intellectual property and the recognition of intellectual property into the domestic legislations of various signatory nations, member nations of these various treaties. The next treaty is the Trademark Law Treaty 1994. Friends, if you see, the Trademark Law Treaty was to harmonize and simplify the administrative procedure. See, the Trademark Law Treaty of 1994 recognized marks for goods as well as for services. It did not only cover only marks on goods, or only covered certain goods marks, rather it covered service marks too in its ambit and in its assets. It is in compliance with the Paris Convention. It is kind of offshoot of the Paris Convention, or say you can offspring of the Paris Convention, but it has one important feature, that is to harmonize and simplify the administrative procedure in respect of national applications and protection of marks. The next treaty, the next international instrument relating to patents is the Patent Law Treaty of 2000. Friends, the salient features of this treaty is to harmonize and streamline formal procedures in respect of national and regional patent applications and patents. And the next aim of the treaty, or the next feature of the treaty, was to standardize and simplify the formality requirements for obtaining the patent at the national and regional level, and to reduce the risk of formality errors, and thus will result in a less frequent loss of rights as well as in cost reductions. So this treaty, Patent Law Treaty 2000, along with the Patent Cooperation Treaty, with the Paris Convention relating to industrial property, they all are going in a same direction to make or to streamline the patent procedure, to streamline the enforcement of the patents, to streamline the intellectual property in a sense. The next treaty that we'll have to look is the Hague Agreement concerning the international deposit of industrial designs. Friends, as the name suggests, that this treaty is having a concern on the international deposit of industrial designs. We have seen so many treaties, they did not talk about the industrial designs so far. We have seen the Bonn Convention, the Paris Convention, Patent Cooperation Treaty, we have seen the Patent Law Treaty, many treaties we have covered so far, but none was discussing industrial designs. This is the first treaty talking on the point of industrial designs, the Hague Agreement concerning the international deposit of industrial designs with International Bureau of WIPO. As I mentioned in the yesterday's discourse, that WIPO is a UN entity, is an expert organization of the United Nations, working for the goal, or working with the goal to streamline intellectual property, to disseminate knowledge about the intellectual property, to tackle with the different issues and emerging issues of the intellectual property. So WIPO has one international bureau. In that international bureau, as per this treaty, Hague Agreement, international deposit takes place of the industrial design, and it can be made through the national office of the contracting state. The very important part of this treaty is that, and the thing that it does in its sweep is that this provides a very easy procedure for the obtainment of the design internationally by doing what? By simply depositing your industrial design into the national office of the contracting state. Contracting state here means, I'll give you an example to make you understand. See, I come from India, I have a industrial design qualified to be given an industrial design protection under the Designs Act, fulfilling all the requirements. I want to have an international protection on my design. So for that, what all I require to do, after this treaty, I have to go to the national office of the designs and deposit the industrial design with them. That would automatically be sent to the International Bureau of WIPO, and that would become a international repository or an asset in the international repository. So this single international deposit may comprise several designs. This is also one of the important features, that you suppose have not only one design for getting up design protection, you have several designs. you can go to the national office of the contracting state, as India is a contracting state of this treaty. So we can always go to the contracting state office, the national office, and deposit the industrial design over there. With that, our prospect of getting the protection internationally will be very convenient and easy. It will be very convenient for the applicant to get it protected internationally because of the help of this treaty. The next and the landmark, I'll call it the celebrated treaty so far, is the TRIPS agreement. Friends, we are done with the WIPO administered treaties. Whatever treaties we have discussed so far were WIPO administered treaties. This is the first treaty which is not the WIPO administered treaty. It is administered by WTO, World Trade Organization. It's a very important treaty, most comprehensive, most expansive, wide, broad, covering so many things, all encompassing in its nature, full-fledged, considered full-fledged so far, and maximum number of countries are the contracting parties, are the signatories of this treaty. First of all, I would like to introduce the viewers at this juncture about the milieu of this treaty, the background, the evolution of this treaty. What was the necessity to have this kind of a comprehensive, this kind of a elaborate, exhaustive treaty? Friends, you see, TRIPS agreement is an offshoot of the GATT. It was in the Uruguay round of the conference of the GATT, General Agreement of Tariff and Trade, that there started a negotiation on the flow of the intellectual property worldwide. The negotiations were focusing on the point of dealing with, or say on the point of streamlining the flow of the intellectual property related properties in the inter-country trade. So that paved the need, or say prompted the need, to have a comprehensive legislation to make the domestic legislations of different countries uniform, have some minimum standards in their domestic legislations, to make some basic concepts uniform in different nations, in all the signatory nations of this TRIPS. So World Trade Organization in the Uruguay round of the conference came up with this negotiation, and the TRIPS was the one of the facets of that negotiation, as GATT provides lot of platform, or a good ample platform, to discuss, negotiate on different facets of the trade. One of the facets of the GATT during the Uruguay round of the conference was the facet in the form of trade related to intellectual property. And of these negotiations, or out of these negotiations, we had this agreement on the trade related aspects of the intellectual property, which is called TRIPS. As I mentioned in the yesterday's discourse, that TRIPS stand for Agreement related to trade related aspects of intellectual property. As the name suggests, trade related aspects of intellectual property. Primarily it was to deal with the trade related aspects, as GATT always looks or focuses on the trade, and smooth trade facilitates the trade between the countries, between different nations. Friends, this treaty is the offshoot of inchoate conventions. First of all, you need to understand that earlier conventions, WIPO administered conventions, they had certain inhibitions, certain limitations in the form of negotiations taking place between the developed countries and the developing countries. But TRIPS had no such. As I mentioned, GATT provides a good platform for the negotiations between the, or good platform for accomplishing the goals of the developed and the developing nations. So TRIPS had no such complication, no such difficulty, no such limitation, and that is why it is called a comprehensive, most elaborate treaty. But it is the result of the inchoate conventions. We had seen Paris Convention dealing only with the industrial property, not dealing with the copyright. Then we had the Berne Convention dealing with the literary and artistic work only, which is a copyright subject matter. We have seen one Hague agreement relating to industrial design. So separate treaties are there administered by the WIPO for separate or say respective intellectual properties. There is no one international instrument, no one comprehensive treaty available to cover, to encompass all kinds of intellectual property. So that was also one of the factors that prompted the need of having the TRIPS. Then the next important facets or the feature of the TRIPS agreement, it is that it has enforcement mechanism. None of the treaty discussed by me earlier had an enforcement mechanism given in the content of those treaties. They did not talk about the enforcement mechanism. They are completely silent about the enforcement mechanism. This is the first treaty where we got the full-fledged part discussing enforcement of the intellectual property. It's a big worry of the owner of the intellectual property as to how his property in case of infringement, how his right in case of infringement will get enforced. So this treaty, the TRIPS agreement on trade related aspects of intellectual property, provided a cure to this problem and rectified this problem in the form of or by the way of providing an enforcement mechanism, a complete full-fledged enforcement mechanism having dispute settlement part also given in the TRIPS. The three essential things that the TRIPS envisaged in its essence and spirit, or three principles I'll call envisaged in the TRIPS, are the principle of national treatment, principle of most favored nation, and principle of right of priority, which was a part of the Paris Convention also. Friends, we'll take up these principles one by one in the later slides. You see, few more information about the TRIPS is that it is universal in character and it has got a arrangement, it provided an arrangement to all the signatory nations. A transitional arrangement was provided to all the signatory nations to become compliant with the TRIPS in few stipulated time period, or say in a stipulated time period. India also was given a transition arrangement time, and in 2005 by having a product patent regime we become the TRIPS compliant and we are fully TRIPS compliant now. Many other nations were also given the similar transitional arrangement and transitional time period for bringing some of the changes into their domestic legislations if they had the domestic legislations, and those countries which were not even having the domestic legislations, they were asked by the TRIPS to have some sort of legislations relating to intellectual property. Friends, this TRIPS agreement balances the rights and obligations, as one of the objective of the TRIPS is under Article 7 that it protects and enforces intellectual property right, and it says that the protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation and to the transfer and dissemination of technology, to the mutual advantage of producers and users of technological knowledge in a manner conducive to social and economic welfare and to a balance of rights and obligation. Friends, if you see the verbatim language of Article 7, it says the protection and enforcement of intellectual property rights should contribute to the promotion of technological innovation. So see, it was not only the private right was not the only purpose or aspiration of the TRIPS, rather dissemination, technological innovation and the transfer of the intellectual property should also take place as per the TRIPS promise or the TRIPS assurance or the TRIPS aspiration. So this is the very important aspect of the TRIPS agreement. Then friends, we have after the TRIPS we have another treaty called Universal Copyright Convention 1952. This Universal Copyright Convention is UNESCO treaty, basically it's not WIPO administered, it is adopted in Geneva in 1952 under the auspices of UNESCO, and it existed side by side with Berne Convention. It runs in tandem with other copyright conventions. Berne Convention is one of the important copyright conventions. Then we have another important feature of the Universal Copyright Convention, that it required copyright registration formalities. Friends, as I mentioned, that the Berne Convention does not require formality for the protection of the copyright. I would like to elaborate this point a little bit to the viewers. We'll see it exhaustively when we'll have a complete discourse on the copyright, a separate discourse on the copyright law in India. See, what this registration formality mean? In the case of the copyright, you do not need to register the work, or you do not need to register your work anywhere. It comes automatically to you. We in India have a Copyright Act 1957, and it provides automatic protection on your work. Whatever you create, you write a article, you author a book, you capture a photograph, you draw a painting, you record a sound, or do any other work which squarely falls under the subject matter of the copyright. In that case, you do not need immediately to rush to the, you are not supposed to immediately rush to the copyright board or the copyright office for obtaining the protection on your work. You get it automatically, because Berne Convention recognizes no formality for protection of the copyright. But this Universal Copyright Convention required copyright registration formalities. It required copyright registration formalities. It's a kind of hampering, I will say, because everyone or every individual may not be knowing about the IP regime, intellectual property regime. So they, in that case, may lose their property into the hands of some miscreants, and others may steal their property and get a copyright protection on their work, right? So this was, to me, is a hampering treaty, and it has lost its importance because of this reason only. Then, friends, we have International Union for the Protection of New Varieties of Plants, 1961, UPOV. International Union for the Protection of New Varieties of Plants, 1961. This convention potentially protects all plant varieties, irrespective of their mode of reproduction or of the technology used in their development. Friends, as we have seen that we in India have a unique legislation, a sui generis legislation, to deal with the protection to the plant varieties and the farmers' rights and the breeders' right. All that is given in our legislation in India is compliant to this particular International Union for the Protection of New Varieties of Plants. This convention protects all varieties. It is an independent international intergovernmental organization with an international legal personality. Its headquarters are in Geneva, friends. And the states which are abiding by this treaty, by this convention, undertake to create a system for the grant of plant breeders' rights within their domestic laws. As I mentioned, that we do have a Plant Varieties Farmers' Rights Act in India, serving citizens of India, people over here in India. It complies with the International Union for the Protection of New Varieties of Plants, 1961, and it does what? It provides to the breeders a right in the form of plant variety protection, in the form of breeder right, and to the farmers in the form of farmers' rights on the subject matter stipulated in the Act, if or subject to the condition that the particular subject matter, the particular claim made by the farmer or by the breeder or by the person owning a plant variety fulfills the substantive requirements of the legislation or given by the legislation. Friends, then we have another treaty, that is WIPO Performances and Phonograms Treaty, It is called WPPT, WIPO Performances and Phonograms Treaty. This treaty recognizes moral rights of the performers as well as the economic rights of the performers. This treaty, this WIPO Performance and Phonograms Treaty, goes in parallel with the WCT, WIPO Copyright Treaty. Friends, the basic thing to be understood is that the most important salient feature of this treaty is that it recognizes moral rights as well as the performers' right and economic rights of the performers. We'll see what are the economic rights, the moral rights of the performers in our copyright lectures later on. Friends, having said so many things about so many treaties, I presume and hope and believe that you have got an idea that we have got a lot of international instruments relating to IPR, streamlining the IP related issues, providing enforcement mechanism, providing dispute settlement mechanism, providing recognition to different kinds of intellectual property. I'll take you to another agenda of today's discourse to understand the general principles of intellectual property. As we have been talking in last 2 days about the meaning, the definition of the intellectual property, the necessity for the intellectual property, the object of the intellectual property, and various other conceptual things I discussed with you. One of the most important things that I would like to discuss at this juncture are the general principles of intellectual property. Friends, if you see the next slide, it gives you idea about the general principles of intellectual property. We have a very first principle of the intellectual property, and this intellectual property principle, which I call a general principle, is a part of the TRIPS also, is a assurance of the TRIPS also. It is concept of minimum standards. Concept of minimum standards. Friends, when we talk about the concept of minimum standards, you see, we have Article 1.1 of the TRIPS providing that members of the TRIPS shall give effect to the provisions of this agreement. Members may implement in their law more extensive protection than is required by this agreement, provided that such protection does not contravene the provisions of this agreement. So what we get from this Article 1.1 is that it requires all the member nations to implement in their domestic laws minimum standards provided by the TRIPS, so that there will be an environment of uniformity relating to the intellectual properties, the procedure for obtaining the intellectual properties, the enforcement of the intellectual properties. This is called a concept of minimum standards, and it has to be abided, complied by all the member nations. The next principle which I would like to discuss is the concept of national treatment. It is also one of the salient features of the TRIPS and of many other international instruments. Paris Convention as well as the Berne Convention had the same principle in their context. You see, this principle of national treatment or the concept of national treatment finds place in TRIPS under Article 3.1. It says and it reads, each member shall accord to the nationals of other members treatment no less favorable than that it accords to its own nationals with regard to the protection of intellectual property. Friends, I would like to put it in a very simplistic manner. In the yesterday's discourse, I gave you an example. If you, being an Indian, wants to own a protection on your work in another country, if that another country is a signatory of the TRIPS, then as per this principle, they cannot discriminate. They can never deprive you of having an intellectual property in their country, and they'll have to give you a national treatment. That means that they will consider as if you are national of their country as far as or so far as the procedure for obtaining the protection of that particular work in that country is concerned and subject matter of that particular country is concerned in rest of the affairs or relating to intellectual property protection. The next concept that we have to understand is the concept of right of priority. Friends, see, this right of priority is a very important right as discussed by me in yesterday's discourse. We find its significance under Article 2, paragraph 1 of the WTO agreement in the form of TRIPS in conjunction with the Paris Convention. In both these important conventions, the Paris Convention relating to industrial property as well as another TRIPS, we find its mention. This right of priority is what? Is a basic purpose, is having a basic purpose to safeguard for a limited period the interest of a patent applicant in his endeavor to obtain international protection for his invention. I would like to elaborate it so that you can understand it clearly. Friends, when you are promised with the right of priority, or your country is a signatory country of one of the international instruments, say TRIPS, you get a priority right when you file international application if or subject to the condition that you have made a application in your country on your claim and that was on a prior date. What does it mean? Let us take an example to understand it. Suppose Mr. A files a trademark application in India for obtaining a trademark protection on his work. He has not been granted the trademark yet by the office. Registration has not taken place. It's still in the process of obtaining the trademark. But this person feels like getting a trademark protection in other countries also, in other nations also. This right of priority helps him in going to other countries and claiming a priority right as he has filed on a prior occasion in his country an application on the same work in the national office of their country. How does this benefit him? See, this process of going to another country, especially in a scenario when there is no option available to him to file it internationally, may take a lot of time. It is very cumbersome for him to go to that nation in person or say many nations in person and to file the application for the trademark registration. So in that case, he'll get a priority right, and with that priority right, he files it in his nation, then goes to other nations wherever he deems or desires to file a trademark registration application and get a priority. Priority means that he will be deemed by the respective offices of their country as if he had filed the application on a prior date, on the date when he originally filed the same application on the same work in their country, back in their country, in his country I mean. Then the next concept is the concept of most favored nation. Friends, Article 4 of the TRIPS places it beautifully and requires all the member nations to give this treatment or to give or abide this concept of most favored nation. With regard to the protection of intellectual property, any advantage, favor, privilege or immunity granted by a member to the national of any other country shall be accorded immediately and unconditionally to the nationals of all other members. As the Article 4 in its sweep clearly shows that whatever privilege, whatever immunity, whatever favor one nation gives to another nation, that nation is bound to accord the same privilege, same immunity, same favor to other nations as well. That is basically for bringing the uniformity. Having said that, I conclude as far as the general principles on intellectual property are concerned. I would move ahead with the next area for the today's discourse. We'll see the various types of intellectual property with examples. As I mentioned, friends, and I have been mentioning since day before yesterday, that we have patents, we have copyright, we have trademark, we have geographical indications, we have design right available. You see, if you look at this slide, we have patents, as mentioned by me, copyright, GIs, industrial designs. I would like to put across certain examples to the viewers to make them understand. They always get to see a lot of things which are patented, but it's matter of recognizing these things. So examples will facilitate you to understand what are the things that can be given a patents, what are the things that are trademark things, copyrightable things, what are the things which are having a design protection. If you talk about the patent, its subject matter is what? The products can get the patent protection and the processes can get the patent protection. I will not elaborate on these points because this I will leave for the special or specific discourse on the patent law in India, which will take place later, in later lectures I mean. But let us see some of the examples of the product patent. Friends, this is one of the historic invention. A snowboard, if you see, it is a newest sport, it's a new sport, it's a recent sport, but if you see the snowboard, this snowboard is a patented thing awarded to Robert Weber in 1973. Friends, it's an example of the product patent. It's a product, snowboard is a product, and this has been granted the patent to this man Robert Weber in 1973. As I mentioned, this snowboarding is a recent game or a very off late game. If you see the next slide, we have another example to comprehend what all are called product patents. You see, this is the example where we see ice resurfacing machine. These are the skates. This is the specification of a skate. Our kids wear skates, they enjoy wearing skates, they go to the street and enjoy riding on these skates, but you must note that these skates and especially the ice resurfacing machines are patented things. This is the specification. Specification means whenever the person files the patent application, he has to provide the specification as to in what manner his or her work works properly, the configuration he has to provide. I will talk about it later in the patent law lectures. The next product patent is the sky lift. You see, this sky lift shown here in this slide is a patented thing. You will be very amazed to know that there are so many things which are patented. Even the bented straw that we use to drink beverages is a patented thing. Sometimes we consume these cola drinks or say cold drinks. We have the smart bottles of the cold drinks now, wherein we find a very unique kind of a cap on the lid of the cold drink bottle. Even that cap is a patented thing. So there are so many things which are patented. As I mentioned in the yesterday's discourse, it's not necessary that the patented subject matter should always be a rocket science. It can be a very simple, a simplest thing, but must qualify the requirements for obtaining the patent. Some of the examples of the process patent: a dry powder composition adapted for sustained release of pharmaceutical agent. May sound very technical for a person coming from a low background, but for a person of the medical science and especially pharma industry, it's not a ticklish thing to understand and comprehend it. If you discern it, these are the processes of making pharmaceutical, processes which are patented processes. The next example is the process of making pharmaceutical composition. There may be a process which makes it easy to make a pharmaceutical composition that can be granted a patent protection. A novel process for the manufacture of pure and doped bivalent metal sulfide nanopowders can also be given a patent protection, and it is a process which is given a patent protection. So there are so many things which are processes and the products can be given easily patent protection. Let's see some of the examples of the trademarks. to make the viewers understand at this juncture when we are talking about simply the introduction to the intellectual property, and I am trying to make the conceptual basis of the viewers about the intellectual property. These examples given in this slide will serve the purpose beautifully. If you see these logos, all of us, or say most of us, are acquainted with these logos. We see them very frequently. We get to see them either on the TV or sometimes with our naked eyes. These various logos shown in this slide are all examples of the trademark, can be given the trademark protection, and are obviously trademark protected things. Then some more examples on the trademark. These various names, or say various brands shown in this slide, are also trademark protected things. Similarly, a lot of examples in this slide, though may not be clearly visible to all of you, but some are very prominent. Oreo, biscuits we always eat, this is a trademark thing. Acer laptops, cell phones we use. Then Kenwood, then we have, you see, IBM, we have McDonald's logo, we have LCBO logo here. So many things are protected under the Trademarks Act. Then some of the examples I would like to share with my viewers on the copyright or of copyright. See friends, as I mentioned when I begin my talk on the introduction of the intellectual property, that several legislations are there existing in India and in other countries dealing with several subject matters. As you have seen just now, that for a patent it's the product and processes which are patentable, but in the case of the trademark the subject matter is altogether different. It's the logos, it's the symbol, mark, representation, signature, smell, as I mentioned yesterday, can also be given a trademark protection. Some of the perfumes are owning a trademark only on the smell. They don't have any name to indicate that this particular perfume is coming from this particular manufacturer or a source. Only the smell demonstrates and indicates the source, and that smell is so unique and can be graphically represented and has been granted a smell protection. I mean, olfactory signs can also be given the trademark protection. In the case of the copyright, we have a different subject altogether. Literary work, artistic work, we have cinefilms, photography, and several other things can be given a copyright protection. If you have a look at this slide, the photography, this photograph is a copyrighted photograph of the person who captured it. I would like to tell to all my viewers that it's not necessary that your photography should have a very outstanding merit. It can be worst photography, still you can own a copyright protection because it's you who captured it. There's no such requirement that you will have to show the merit in your work. So is the case in the case of the painting. Though this painting shown in this slide is the remarkable celebrated painting, but even if you paint very badly, you can own a copyright on your painting and nobody else can imitate it. And imitation is a human behavior. As rightly said by this scholar, I don't remember his name, that from cradle to grave, a human being keeps on imitating others. So in case you imitate, you will be liable for the infringement. Otherwise, no merit is required on your copyrightable subject matter. The next thing, example, or you can say, of the copyright is the literary work. You author a book, you get a copyright protection. No merit. What is the literary merit of your book? But it should not be undoubtedly substantially copied, or you can say must not be imitated work of other. Then we have sculptures to give you or to make you understand. As far as the examples of copyright are concerned, these are copyrighted things. Sound recording done by the person in a studio. Friends, I would like to pause here for a moment to make you understand that it's not the song on which a person will own a copyright. I'm talking about the sound recording here. This man shown in this slide is doing what? Is recording this sound, sitting in this studio. and when he records it, he applies his creativity, he applies his judgment, he applies his skill, he applies his mind, and whatever comes after this application is the offshoot, which is called the intellectual property in the form of the copyright on that sound recording. Some more examples on the copyright: performance, cinefilms. You see, the performers are performing in this slide. They are playing with their musical instruments, singing over there, and doing some other activities. This is one kind of a slide, one kind of example shown. There can be other examples, or numerous examples can be brought under the ambit of the copyright, especially the performances, actor performing in a movie, a teacher performing when he delivers a discourse in his classroom, or a person who is an orator performing in a public forum anywhere, or a dancer performing a belly dance in a hotel or a theatre, or any other performer, a magician, a person doing a yoga, or anything like that can be given a performance right under the copyright. Then cinefilms are also protected. But friends, I would like to tell you that in the case of the cinefilms, not only one person owns a copyright on a cinefilm. There are several people working together in tandem, cumulatively owning a right on this cinefilm. Some examples of the geographical indications I would like to put across, as I will have to finish this introductory part today. Let's see it quickly. We have Muga silk of Assam. This is a very famous silk of the Assam. It's a geographical indication protected thing. Then handmade carpets of the Mirzapur are also having a geographical indication. Meerut Caesars has been granted the geographical indication of late. 2 months back only it has been granted. This industry is a 360-year-old industry. Then Darjeeling tea is a common example to be understood. It's also what? A geographical indication, which is intellectual property. And as I mentioned in the yesterday's discourse, that GIs are what? GIs are community right, unlike other intellectual properties which are individual rights. Then some examples on the industrial design. This is a old monk bottle, a liquor bottle. This is a design protected under the Designs Act. So is the case of other designs of a table, design of a desk, design of a mobile phone, design of any other thing. It can be given easily a design protection. A t-shirt of Ed Hardy, a textile you see, if you see in this slide, is what? Is a design, and it's protected under the Designs Act and can be easily protectable under the Designs Act. Then one last thing, that's a design of a shoe given here is also a design protected thing. So I rest here friends, because the time is over. I would like to cover rest of the things in the later ensuing lectures, and I believe that we will stay tuned for the later lectures in the next week, wherein we will be covering the specific IPs, patents for 4 or 5 lectures, and the copyright for 4 or 5 lectures, and that is how we will proceed in the next lectures. Thank you so very much. Thank you, Gitika.
Thank you, sir. Thank you so very much for giving your precious time. And dear friends, if you have any queries, you can mail us at info.cc@nic.in. Thank you once again, sir.
Thank you. Thank you, viewers.